All right, everybody, here we go. This video lecture is going to look at some other rights movements in addition to the African American civil rights movement that we've discussed in class. I think it's important to highlight that even though oftentimes when we talk about civil rights, we focus a lot on the African American civil rights movement, many other groups have had their rights movements as well. So in this lecture, we're going to very briefly cover the LGBTQ rights movement along with the women's rights movement. I think important to note that both of these movements are still ongoing, in flux, and works in progress. Now, with the LGBTQ rights movement, it really started with the Stonewall riots at a New York City bar in 1969. This occurred when the police raided the Stonewall Inn, which was a bar frequented by predominantly gay patrons who resisted arrest. This act of resistance is really what is considered to be the spark of what was at the time called the gay rights movement. We have expanded now that term to include LGBTQ plus individuals in here as well. That was kind of the impetus and the spark for that, and you can see a couple pictures here of that movement. Now, in 1986, a Supreme Court case of Bowers v. Hardwick actually ruled that states could ban relationships between gay individuals, and that was kind of the working rule for another 10 years. However, in the case of Romer v. Evans in 1996, we see this expansion that perhaps gay individuals, LGBTQ plus individuals, have the same rights as straight individuals do. And in this case, the Supreme Court actually voided a state constitutional amendment that had been approved by voters that actually denied gay people protection against discrimination, saying that that amendment violated the rights of gay individuals under the Equal Protection Clause of the 14th Amendment. So through this ruling, the Supreme Court made it clear that LGBTQ individuals have the same right to seek government protection from discrimination as any other group of people. In 2003, 17 years after this, in the case of Lawrence v. Texas, that Bowers decision from 1986 is actually overturned. So the Supreme Court overturns a previous decision, citing due process and a right to privacy as a reasoning for overturning that Texas ban on homosexual relations. And it was this idea that laws regarding private sexual conduct violated an individual's right to privacy. And this idea that the government shouldn't control what happens in the private home or bedroom of the American people. Another important kind of milestone in this movement was the repeal of Don't Ask, Don't Tell. Don't Ask, Don't Tell was a policy that basically said you couldn't serve in the military if you were openly gay without being potentially the threat of discharged from the military. So repealing Don't Ask, Don't Tell meant that military personnel who were gay could serve and also be openly gay and not have to hide that anymore. And then finally, on this slide, in 2015, the Supreme Court, in the case of Obergefell v. Hodges, ruled that same-sex marriage would be legal in all 50 states. And this is a great example of the Supreme Court kind of following public opinion and following trends. Prior to this decision, multiple states had started to legalize same-sex marriage. Public opinion on this issue too started to increase. So if you look, in the 13 years or so from this data starting until that 2015 decision, almost a 20% swing in the approval of same-sex marriage. Now, moving on to the women's rights movement. Women constitute a slight majority of the American population. but women have had to fight very hard to secure civil rights throughout our nation's history. And there are really two distinct waves here. The first one in the 19th century really focused on the right to vote, and then in the mid 20th century, after the right to vote is secured, focusing on issues of equality and discrimination, specifically in the classroom and the workplace. And the key strategy in both of these waves was really to focus on changing the laws, focusing on a legislative strategy. So that first wave in the 19th century started with the Seneca Falls Convention. And this was a convention that was talking about women's rights and equality. And Elizabeth Cady Stanton, an early pioneer, along with Susan B. Anthony, were really important in kind of laying out this vision. And Elizabeth Cady Stanton in 1848 drafted the Declaration of Sentiments, and where she says, "We hold these truths to be self-evident, that all men and women are created equal." And if you notice, she's playing on that language from the Declaration of Independence and showing that we are not truly going to be a free and equal nation until women have the same rights here. So Elizabeth Cady Stanton and then Susan B. Anthony are going to focus on the right to vote. They're going to focus on enfranchising women. The franchise is the right to vote. Enfranchising means giving that right to vote. And we see throughout the 19th century, there were actually states that started to allow women the right to vote, especially out west, as Western territories became states. Wyoming was the first to allow women the right to vote in 1869. The National Women's Suffrage Association, which was led by Susan B. Anthony, focused on national enfranchisement and working really on a state-by-state pathway to get women the right to vote. And by 1918, 15 states had passed laws allowing women's suffrage. The 19th Amendment, ratified in 1920, gave the right to vote to women nationwide. And it reads, "The right of citizens of the United States to vote shall not be denied or abridged on account of sex. Congress shall have the power to enforce this by appropriate legislation." Now, the second wave then was starting really in the 60s, where we had this women's rights movement, which was again very much focused on changing the law and focused on tackling issues of inequality at work and home, and to protect women from violence and sexual harassment. And now the National Organization for Women was an interest group that was very focused on fighting and advocating for these issues, pushing for change in the legislature and also the Supreme Court. This organization was founded in 1966. Betty Friedan was the first president of this organization, a big leader of the second wave feminism, or the second wave of this rights movement. And she says, "The purpose of NOW is to take action to bring women into full participation in the mainstream of American society now, exercising all the privileges and responsibilities thereof in truly equal partnership with men." Now, the Civil Rights Act of 1964 was important for civil rights for African Americans, but it was also crucial to women's legislative and legal efforts. And that was because of the inclusion of Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment based on race, color, religion, national origin, or sex. So there's going to be lots of lobbying by women's groups for strong enforcement of Title VII, protecting women from discrimination in their jobs. Throughout the 60s and 70s, women's rights groups will have major victories in securing several important pieces of legislation to protect and advance the equal treatment of women in workplaces and schools. And Title IX is one of the most notable provisions protecting women's equality in education. And Title IX, even all these years later, is still crucial and instrumental in protecting and providing gender equality on campuses and schools in terms of education and academics, extracurricular activities, athletics, and at college admissions. And it had a tremendous impact. And probably the strongest impact of Title IX can be seen in female participation in sports, where in 1974 there were fewer than 300,000 girls playing high school sports, and in 2019 we have over 3.5 million girls playing high school sports today. And Title IX, this part of this Higher Education Act of 1972, a piece of it reads, "No person in the United States shall, on the basis of sex, be excluded from participation in or denied the benefits of or subjected to discrimination under any educational program or activity receiving federal aid." You can see the impact that this has had then on not only high school sports, but on college sports too. Another important attempt here to secure equal rights for women is the Equal Rights Amendment, the ERA, which reads, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." Now, this constitutional amendment was actually proposed very shortly after the 19th Amendment was passed and ratified. It was introduced in every session of Congress since 1920. It is still introduced today, currently, but the closest it got to passage was in the 1970s. It easily passed through the House in 71, the Senate in 1972, and 5 years later, 35 of the required 38 states had ratified the ERA. Unfortunately, the clock ran out on the ERA to ratify it. And in 1982, it expired and ultimately failed to be ratified by the required number of states for it to be added to the Constitution. Part of that is because, as we know, the ratification process was made to be difficult. Those high thresholds, 2/3 Congress, 3/4 of the states. But there was also some controversy surrounding the Roe v. Wade decision in 1973, and it really probably mobilized people who were in opposition to the ERA and was detrimental to its overall passage. Now, talking about gender discrimination and sexual harassment, remember that SCOTUS has these different standards to determine the constitutionality of laws that treat specific groups differently. They will use strict scrutiny when we're looking at race discrimination. They will use intermediate scrutiny when deciding on cases involving gender discrimination, and a rational basis for other things, maybe like age or some requirement like that. So when we look at laws or cases that deal with gender discrimination in general, the court has found that most forms of differential treatment for men and women are unconstitutional, except when such treatment can be justified as serving important government objectives. And one of the things that still stands today that the court stands behind is that only men are required to register for the military draft. Also, in terms of gender discrimination and sexual harassment, if we bring it back to Title VII of the Civil Rights Act, it doesn't explicitly mention sexual harassment in employment here, but SCOTUS has ruled that sexual or gender-based harassment violates the Act's anti-discrimination provision. One of the things that's looked at is this idea of quid pro quo harassment, when employers request or demand sexual favors in return for advancement in a job or to get a job, and also in fostering a hostile work environment. So where actions, statements, or conditions interfere with the ability of employees to be able to do their job. Today, when it comes to kind of questions of gender discrimination and equality, there's definitely continued focus on those two things. I think the Me Too movement kind of highlighted some of those things, and the movement may have died down a little bit, but I think there's still a focus on that. We're looking at women in positions of power, and how in 1992 we started to see more and more women elected into political roles, political leadership. We're still in the debate of the extent of and access to reproductive rights. Roe v. Wade is still a very polarizing case. This tug of war and debate between those who are pro-life and pro-choice, the Supreme Court overturning Roe v. Wade, now kind of passing that question off to the states, and even questions surrounding access to birth control methods and other things like that. So there are still unsettled debates and unsettled questions on the road to women's rights. All right, that's the end of our video lecture. If you have any questions, make sure you come to with them to class tomorrow.